The Northwest Law and Mental Health Conference brings together expert speakers with legal, clinical, and lived experience to discuss the impact of the law on people with mental illness and addiction. Our spring 2020 conference was postponed due to COVID-19, so presenters recorded their sessions, which are now embedded in the conference website along with their collateral information. Thanks to all our expert presenters, generous sponsors, exhibitors, volunteers, and the planning committee for the Northwest Law and Mental Health Conference. Stay well, and we hope to see you in 2021.
My name is Alison Bort, and I'm the Executive Director of the Psrb. I've been in that position since June of 2018. And I wanted to let you all know that I'm so happy to be here. Part of my role as a director is to make sure we are equipping our partners like you in the legal community with all of the tools to best understand our program. And so without further ado, I'm going to be getting started here. So here are some of the major takeaways that I'm hoping to impart on you today. First, the Psrb is more than just the entity that oversees the guilty except for insanity population. We have 5 different programs that assist justice-involved individuals who have mental health diagnoses. Another big point today is to let you know that when you are sending a client under the Psrb, you're sending them into one of the most robust comprehensive treatment and supervision programs that exist in the mental health system in Oregon, and I would also argue maybe even nationally. We want to enhance both monitoring and supervision as well as treatment, and so what you're getting is the best of both worlds, recovery and public safety. I do also want to let you know throughout the presentation that I'm giving you resources and tips to our website, but you can call our office at any time. Some of these concepts may be a little foreign until you're actually doing some of the work itself. So feel free to get the pointers today, but then give us a call when you really run into problems and we'll get you out of the weeds. But we have tons of templates, handbooks, and other resources available to you on our website. And lastly, we are always happy to come out and do a more in-depth presentation on any particular program. So today I'm going to be doing a real big overview of our programs, but we can get more into the nuts and bolts of things depending on what your agency might need. So just a quick view of the history of the Psrb. It was created in 1977 by the Oregon legislature and went into effect in 1978. At that time, the focus was really on the population who would plead guilty except for insanity, or the insanity defense back then, and how we treated that population afterward. So we had multiple judicial decision makers throughout the state making variable decisions about when somebody should be discharged back into the community. And when those people would be discharged in the community, they were based on, those decisions were based on really medical versus legal types of decision making. And also, when people went back out into the community, there was no tracking, monitoring, or supervision of them. So the Psrb came together and said, or the Psrb really created an opportunity for everybody who was pleading GEI, guilty except for insanity, to be with the same body of individuals who'd be making consistent decisions. And it added the component of the monitoring and supervision of those individuals once they were conditionally released in the community. Over time, we've grown and expanded, and I'm going to go over some of those other programs we have. We've created a reputation in the community for public safety and also recovery among the people who come under us. You know, for instance, our recidivism rate for recommitting acts while people are on conditional release is about 0.5%, which is extremely low. So a little bit about what the Psrb looks like. So there are 2 different panels with 10 total board members. Each panel, one's an adult panel, one's the juvenile panel, and each panel has a position, a parallel position, including a psychiatrist, a psychologist, an attorney experienced with criminal practice, a parole probation officer, and a member of the general public. All of our board members are appointed by the governor, and then they're subsequently confirmed by the Senate. And just a little bit about them, these are not board members who are working full-time. They all have full-time other jobs or other commitments that they do, and they provide this as a public service to the state of Oregon. So we have very interested, passionate people who really care about this population and care about their outcomes. All of our board members are they're at term limits, so they can serve 2 4-year term limits. After their first 4 years, they reapply, and then they can do a second 4 years. So our mission is to protect the public, and sometimes that gets a little confusing because I think sometimes people might think that means protecting the public is, locking people up and throwing away the key. And so it's important to impart that, the Psrb is protecting the public by working with people in the community, our partnering agencies such as the county mental health systems and our community mental health partners, the legal community, law enforcement. And what we're really trying to do is ensure that the clients that we're serving are getting the necessary services and support so that they can live a meaningful life out in the community, figure out what it is that got them under the Psrb in the first place and resolve those issues, and get the necessary treatment and resources so that nothing like that will happen again. Nothing like their instant offense would happen again. So a little overview of the different programs we have. Like I said, we're going to be going over all 5 of these today. That's going to be my approach. I'll be giving a little snapshot of the program and then really focusing in on a few strategies and key features of those programs that you as legal practitioners may want to be aware of. So the first and our most popular, largest program is those adults who successfully assert the guilty except for insanity plea. We also have a parallel, like I said, we have a parallel juvenile Psrb, and that's known as responsible except for insanity rather than guilty except for insanity. Okay, so the third program that we have is a bit newer. We have our Psrb civil commitment, and that is very different, as you'll see, from the traditional civil commitment. We'll get into that program in depth today. Fourth, we have our gun relief program, and those are one-time events that we have with different clients who petition to have their firearm rights restored. We'll be talking more about that. And lastly, and most recently, the board has been delegated to develop a sex offender reclassification and relief program. This involves classifying those individuals who are found GEI and have a sex offense, and it also involves later on reclassifying those numbers as is appropriate and people petition, and also relieving individuals of sex offender registration requirements. We'll be talking more about that as well. As you can see with all of our programs, the big things that we do are conducting a lot of hearings and supervising a lot of people. If you think of, you can kind of think of our programs in 2 different ways. The top 3 are people who have sustained jurisdiction over us for a period of time. So we have several hearings and we supervise those clients for quite a bit of time, versus the bottom 2, the gun relief program and our sex offender classification, reclassification relief program, where we may or may not have more than 1 hearing, depending on what the issues are in front of us. But do note that some people who apply for gun relief or sex offender reclassification may have also been in one of those top 3 programs as well. The final big duty that we really have, again, like I mentioned in the beginning, is to make sure that people like our legal partners, our law enforcement partners, our community provider partners, the Oregon State Hospital, that everybody's really speaking a common language around all of these programs. And so a big part of my role is to do the outreach, also at the legislature. So we're going to get into the first program here. As we move through each program area, like I mentioned, I will be giving you a bit of an overview of that program, but then really I'm going to get into some cool strategies that you may or may not have known about that would be helpful for your representation, even if you're a district attorney or if you're a public defender, even as a judge, kind of understanding how some of these things work. So in Oregon, you may or may not be familiar with the insanity defense, but here in Oregon, we follow the American Law Institute Model Penal Code's version of that statute, which is one of the broader statutes. And that is as a result of a qualifying mental disorder at the time of engaging in criminal conduct, the person lacks substantial capacity to either appreciate the criminality of the conduct, that's known as the cognitive prong, or you don't have to have both, it's an either or, conform their conduct to the requirements of the law. So I don't want to get too far out of my scope in explaining what these are. People go through much more training and become experts in these prongs, but in general, you can think of the cognitive prong as a situation where the person didn't know what they were doing was wrong, or they might have been under some kind of psychotic moral justification. So they might have known it was wrong, but because of the delusions that they were having at the time, they felt justified in their actions. We compare that to the volitional prong, which is often a little more difficult to prove. And typically, if you're already meeting criteria for the cognitive prong, then or if you're meeting the criteria of the volitional prong, you would be meeting the criteria for the cognitive prong as well. But here under volitional, the evaluator might be looking at factors like the defendant's capacity to make choices. They might be looking at their degree of regard for apprehension after they've committed the crime. And they might be looking at their capacity to delay their actions. So that's just like a little snapshot of that. This is a defendant-driven defense. So there have been statutes and case law that have come out over the years that really make it clear that even if everybody in the courtroom agrees that somebody could successfully assert the insanity defense, that it's really only the defendant, him or herself, who is able to do that. So it's something that once the elements of the crime have been established, the defendant is then able to make an affirmative defense by the preponderance of the evidence. So the trial judge is not able to impose this defense, and neither is trial counsel. Some other rules that you might want to be aware of, just some key rules. The way the process works is, as soon as everybody realized there might be a GEI or some kind of mental health issue that happened at the time of the crime, the defendant then gives some kind of notice of intent that they are going to be asserting that defense. Along with that is an evaluation that's been completed by a certified evaluator, and we'll talk a lot more about that in the coming slides. And then the state will have their own right to obtain an independent evaluation. That report needs to be conducted after the date of the alleged defense, because really what we're looking at is an evaluation that's looking at all the factors that were occurring at the time of the crime. They're not looking at things that happened in the distant past, and they're not looking at things that happened after the fact necessarily. It's really, you're looking at what happened at the time of the crime, so it has to come after. With regards to these evaluations, a lot of the elements of 161309 came from House Bill 3100. And so prior to that, not all GEI pleas were required to have one of these evaluations. But since then, they are required in order for the court to accept a GEI plea. And then most recently in 2019, the challenge here was that there were a lot of clients who were under the misimpression that when they pled GEI, they were only going to be sentenced for the same amount of time they would have been sentenced if they had just pled guilty. And so there were people feeling like they were misinformed, they didn't really understand the sentencing, and then after the fact felt very confused and upset. And so what happened in 2009 is that legislation was passed where the judge now has to give a colloquy prior to accepting the plea of GEI to a felony. The court shall inform the defendant of the possibility that the court may order commitment or conditional discharge after entry of judgment, and of the maximum total period of commitment or conditional discharge. This gives the defendant one more opportunity to say, whoa, 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 I didn't think I was pleading to 20 years here. I thought I was only going to be doing 5. And so it's just one more thing. Now that should have always been happening anyway, but this requirement makes it, it's a requirement that it's done on the record. So that's a real gross overview of what the GEI defense looks like. And we're now going to be getting into, a few things that you might want to be considering. The most important one, I'd say, and the one that the Psrb has the most vested interest in our legal community knowing about, is that not everyone diagnosed with the mental illness should be found guilty except for insanity. And we're going to kind of talk about why that is. Okay, so back to that criminal responsibility evaluation I was mentioning before. This is the cornerstone of protecting the Psrb from inappropriate admissions. And you as attorneys are the gatekeepers to this. So we really want to make sure that our attorneys are familiar with what the key components of a criminal responsibility evaluation, what the key components are, and how to kind of look for red flags or other things that might caution you to having the person successfully go toward, be transitioned to the Psrb. So one of the biggest dangers of an inappropriate GEI adjudication is that the Psrb could be put into a place where they must discharge. And we're going to go over why that can be. The other big thing for attorneys to know is that a criminal responsibility evaluation is distinct from a competency evaluation, or an evaluation known as the 370. So the criminal responsibility eval could be a part of a competency evaluation if the finding of that competency evaluation is that the person is able to aid and assist in their defense. If you ever see a competency evaluation that says the person cannot aid and assist in their defense, or either can't right now or in the foreseeable future would never be able to, you should not see after that an analysis for a GEI, because the competency issues must be resolved prior to engaging in any kind of GEI analysis. So that's one thing to make sure. In addition, a competency evaluation cannot be substituted for a criminal responsibility evaluation. Another thing, I mentioned it before, but just to reiterate, is that a criminal responsibility evaluation is an analysis of the qualifying mental disorder at the time of the offense. It does not matter what symptoms the person was experiencing 3 years ago, and it doesn't matter what symptoms the person is experiencing at the time of trial. The important focus is on the qualifying mental disorder and the symptoms that were present at the time of the offense. Because of this, there's a real heavy reliance on historical information. So a really good tip for you all to keep in mind is that you really want to equip your evaluators with as much collateral historical information you can about what was going on at the time the criminal act occurred. Looking at hospital records, looking at jail records, looking at lab results, and looking at the interviews of the different people. So you can really make the evaluation stronger by equipping your evaluators with that information. And the last big oversight thing I want to say about evaluations is that you have to know that there's wide variability in the skill sets that our evaluators have. We have a lot of psychologists and psychiatrists who are certified to do these types of evaluations, but there's wide variety in their experience, in their background and training. What's common among all of them is that they've received a training and passed an exam and turned in a few reports to get a certification. But you really want to vet the people you're having do these types of evaluations. And we'll talk a little bit about the best practice would really be getting two of them, so you can kind of see what one's perceiving versus another, and see what kind of reliability there is in between them. The Psrb is a faculty member of the Certified Forensic Training Program. And so we share some of this information that I'm sharing with you today with the people who perform these evaluations. But it's important that attorneys are also equipped with these skills. Just to give you an oversight and a quick checklist, even if you were interested, is that OAR 309-090-0025. You can go there and you could look at all the things that you should be seeing in one of these criminal responsibility evaluations. So a quick checklist. We're going to focus on just a couple of them right now, the key ones, in my opinion, from the Psrb's point of view. So first of all, we will take a look at the qualifying mental disorder. So qualifying mental disorder, as I've used that term a few times, we're going to now define it. And you'll see it's not very well defined. What it is not well defined. What the statute says is it does not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct, nor does the term include any abnormality constituting solely a personality disorder. There's been a lot of conversation about whether or not we need to be defining what a qualifying mental disorder is and codifying that versus relying on a definition that says what it is not. And I'll talk a little bit more about why in a bit. But we do have some OARs as well that kind of help our certified forensic evaluators understand what might be included in that definition. So, individuals who have severe persistent mental illnesses, people who have traumatic brain injuries, people with intellectual disabilities. But what you're really looking for is that the diagnosis exists in the DSM, the current version of the DSM, which is DSM-5. So that is key. But the take-home message here is that there is a bit, maybe even too much variability or range of options of qualifying mental disorders. And we can kind of talk about why that might not be a good thing in terms of a GEI defense. So the first thing that I wanted to note about the GEI defense would be it's different from the criteria the board has to look at to sustain jurisdiction. So just to alert you to the jurisdictional criteria for the Psrb, I have that highlighted up under the heading. Does the individual have a qualifying mental disorder that when active makes them a substantial danger to others? So if you keep that criteria in mind, you can kind of understand the pickle that the Psrb might be in some of these situations. So the first and probably the most problematic that the board has is when they end up with jurisdiction over a client who may have had a tricky diagnosis that looked kind of like one that was a qualifying mental disorder, but also had some other comorbid condition that was a non-qualifying mental disorder. So some of these things have already been explicitly called a non-qualifying QMD through case law. Others are part of the statutes. So these are sexual conduct disorders, including paraphilias. That would be like pedophilia, substance use disorders. More recently, a court indicated that a transitory drug-induced psychosis, but long-term or organic damage due to substance abuse is still an open question, is not a QMD. So the transitory drug-induced psychosis, not a QMD. And a personality disorder. Those are not. Even personality disorders that might be treatable are not considered qualifying mental disorders. So you might be able to start to see that in the worst case scenario, it would be something like somebody used meth for a period of time and the meth induced psychotic features. And while the client was experiencing those psychotic features, they went out and committed a crime. And so the certified forensic evaluator has to parse through whether or not that crime was more attributed to some kind of underlying mental health condition or through the meth use. With the gift of time, we sometimes will be able to see that, but oftentimes these cases, due to people's constitutional rights, are moving pretty quickly, and that time is sometimes not available to people. So what you'll want to do as a legal practitioner is you'll want to be looking at the qualifying mental disorder that's chosen, and you'll want to be looking at whether or not some of these other things have been effectively ruled out, or if the evaluator might be teetering, like can't quite say which one it might have been. That could be a red flag, because when they end up under the Psrb, if it turns out that it was a meth-induced psychosis that made them dangerous, or it was a personality disorder that made them dangerous and not that qualifying mental disorder, the board will need to discharge that person. A second less common red flag to be looking for would be somebody who's using a non-DSM diagnosis. So there are a lot of syndromes that exist out there that never made it into the DSM-5, even though practitioners have working hypotheses using these syndromes. So things like calling something Asperger's syndrome versus autism spectrum disorder, or parental alienation syndrome, pathological demand avoidance, sensory processing disorder. These are, this is a language that we would have to discharge if somebody decided to choose one of these as a qualifying mental disorder. Hopefully that won't get, no one will get caught up with that one, but just a little caution. The next two are really more of a cautionary tale for you. So when we're thinking about people who are asserting the GEI defense, the people who fit best for our programming are people who are experiencing chronic conditions, lifetime conditions that involve psychotic processes or extreme mental disabilities and cognitive challenges. So the first one here, a non-psychotic or non-chronic illness, these have all been used as a qualifying mental disorder for the purposes of a guilty except for insanity plea. The problem is that typically it's difficult to connect any of these diagnoses to ongoing danger. Usually there might be something else going on for people with these conditions that could make them dangerous, like a personality disorder or a substance use issue, or maybe even some kind of general medical condition. And so what could happen on the other side once they're under Psrb is that as more and more people are evaluating them over time, they might come to this conclusion that, well, really it's not any of these diagnoses that make them dangerous, or that these diagnoses are managed very effectively with the medication or other treatment, that the person ends up being discharged, not because they don't have a qualifying mental disorder, but because that qualifying mental disorder, when active, does not make them a substantial danger to others. So this could result in we call an early jurisdictional discharge. So somebody who might have been sentenced for 20 years ends up getting a discharge in 5. That could create a lot of public perception of that, people getting away with it. It could really be harmful to victims. So it's just a cautionary tale. That being said, we, as a board, we want people to get better. We want people to benefit from the comprehensive treatment that we provide in our programs, and for people to get better and stable and resourced and all of those things. So an early jurisdictional discharge, if you keep in mind that most people who plead GEI, their sentencing is well beyond what somebody who just pled guilty would be. So if somebody were to have a Class C felony, and they might do, a year and then a year of probation, versus most of our Psrb clients would be doing the full 5 years under the board. So just something to keep in mind. The other one would be, look out for things, diagnoses that are really mild, really acute, or unspecified. Again, these things could qualify as a mental disorder, but with the gift of time and more evaluations, they're likely to resolve or to be better captured with perhaps a non-qualifying mental disorder. Lastly, I wanted to talk a little bit about malingering, and malingering is a very big deal. The definition, if you don't know the definition, this is a diagnosis. It's a formal diagnosis for those people who are found to be faking a mental illness to get some kind of secondary gain. And in our population, that secondary gain is typically going to be some kind of avoidance of prison or punishment. Just say you're crazy and then you can, escape the prison sentence. It does not happen so often that somebody can trick a trained professional into some kind of mental illness. Usually there's tons of other evidence, and especially with the passing of that House Bill 3100 in 2011, the standards for our forensic evaluators are much, much higher. However, you should be looking in that criminal responsibility evaluation for a specific rule out of malingering. That is a requirement by the OARs. So you're looking for a little section and you're looking to see, did the evaluator what did they use to assess whether or not the person is faking their symptoms? Did they use an evidence-based actuarial tool? Did they just do clinical judgment, which is also fine? But what was their analysis there? An example of this came up recently where We had somebody who was requesting a full discharge from the Psrb. And when I went back and I read the criminal responsibility evaluation, I saw this section on malingering that said, you know, they administered a tool and the person was elevated on the tool for malingering. And then the conceptualization was, yes, but in the totality of the circumstances, I don't think he was malingering. That's, you know, statements like that, you want to be asking a few more questions. Like, well, what makes you so sure? You used a tool that's been normed on this population. It's suggesting that the person malingering is malingering. So what was the evidence that made you think otherwise? Why are you dismissing the data? Those should be questions that you might want to consider asking. At the very bottom, what I included were some seminal cases, Court of Appeals and Supreme Court cases that might be of interest to you if you wanted to know more about qualifying mental disorders. So remember, we're talking about three key components here. The next one is about nexus. So nexus is this legal term of art around connecting someone's qualifying mental disorder to the actual act. So what I have for you here is I think I have on the next slide, yes, the article where I pulled these from. There's a really great article that I have in the notes here for you to look at that talks about the best practice around evaluating people for the GEI defense. But I was looking at these offender patterns and when you might want to question the evaluator more if you're seeing one of these patterns or not seeing it. So the most common pattern that we would have in our system would be, you know, an offender who definitely was experiencing symptoms at the time of the crime, and there was nothing else going on for that person. All they had was a qualifying mental disorder, and it's very clear that when they were symptomatic, they committed the act. I mean, that's the best case scenario, but here are some that you might want to look at that would not meet the criteria. You want to look at offenders who have personality disorders, and you're looking at their crime. The type of crime they did might be consistent with a maladaptive pattern of voluntary and knowing behavior. So again, going back to those cognitive and volitional prongs, was there planning involved? Is there a history of criminal behavior? Is there, when the person's not symptomatic in particular? And you're looking for motive, you're looking for things of that nature. Another pattern might be somebody who has a genuine qualifying mental disorder, but it's totally coincidental and unrelated to the crime. That would be more like those ones I was telling you about, like an ADHD or a mild developmental disorder. You know, maybe those crimes, maybe those diagnoses were connected to the crime, but less likely. Just coincidental that they happen to have a QMD. Then you might have an offender who has a qualifying mental disorder, but that qualifying mental disorder actually was brought on by the crime. So after committing the crime, they either witnessed something very traumatic, or maybe somebody was defending themselves and the defendant was shot or went through some kind of pain, and after that developed PTSD. So that would not be a qualification for the GEI defense, because the qualifying mental disorder was not the reason the crime was committed. It was something that occurred and developed after the crime. And then lastly, and this was one that I added, you could tell it's a different font, but this is the one I kind of see in our world, and that's offenders who have a genuine QMD. However, a non-QMD, like the personality disorder, like the substance abuse disorder, or some other condition, better explains the basis for the crime. So again, just make sure you see those evaluators ruling out those other possible explanations. I really encourage you to take a look at this article if you get a chance. In preparing for this presentation, it was the first time I had read it, and I think it gives a real succinct overview of the best practices involved in insanity defense evaluations. Okay, so we're going to move on to another consideration. And perhaps you may or may not have known this, but people who commit misdemeanors can be found guilty except for insanity. And historically, people who committed misdemeanors were and found guilty except for insanity were placed under the Psrb's jurisdiction. And that kind of accounts for this mass change from like having 800 people under our jurisdiction and then having like 200 of them be moved out when the law changed in 2012. I'm not saying that we want to criminalize anybody who commits a misdemeanor, but you may want to consider this for individuals who might be repeat misdemeanants, or who you are hoping to get some kind of access to care that they just have not been able to get using the current legal system. Maybe there's somebody who constantly flies under the radar of that threshold of civil commitment with the imminent danger to self or others. And there's just maybe the mental health court is just not an option for them for whatever reason. But if they plead GEI for a misdemeanor, you have really two options there. The judge has the option to, if they're super dangerous to themselves, there's the option for them to be going to, I'm sorry, let me back up. If they're a substantial danger to others, not to themselves, then they can be committed to the Oregon State Hospital for a period of time. And as soon as they get the treatment they need and they're no longer considered a substantial danger to others, they can be discharged back into the community. And the social workers there would be working to set up that discharge plan. Alternatively, if somebody is fine and stable at the time of the disposition, the judge would order a discharge. So in some ways that would lead to a conviction on their record of the misdemeanor due to a GEI, rather than a conviction of a misdemeanor, or just dismissing the misdemeanor and having the person cycle back and cycle back and cycle back. So I've seen a few cases where there's been a series of misdemeanor GEIs adjudicated. They know the Psrb doesn't see those, but then something bigger happens, and then they plead GEI for a felony, and then they end up under us. So then you see this series of GEIs. Some of the benefits for doing this would be that a GEI is not a conviction for the purposes of taking away someone's housing, for employment or applying for housing. People can still vote. So in that regard, it's not meant to be a conviction for that purpose or used as a conviction. But some drawbacks might be that, we still have to do those criminal responsibility evaluations. I don't know if the person would be living in the community while that's happening or in jail. That would be a drawback if they were not able to be released while all of that was going on. And then also their firearm rights, for better or worse, those prohibitions would apply because this would be a mental health determination. There's a paper published back in 2005 while the Psrb was still overseeing misdemeanors that kind of made the case. So it could be a good article to take a look at and just see. It's just another tool in your tool belt for how we might be able to keep people who commit misdemeanors out of prison and get them into the mental health system and stabilized. So the next thing that I think is good for legal practitioners to know about is that maximum sentencing is not required. So earlier on, I alluded to oftentimes people under the jurisdiction of the Psrb are sentenced for way longer, many years longer than those who plead guilty to the same exact crime. And there have been some movements in the legislature about, okay, well, why can't we just sentence people under the Psrb to the same under the same guidelines as we use for anyone else, but those have failed. But one thing that didn't fail was that the statute 161327 section 5 changed from mandating and requiring the sentence to be the maximum sentence to may not exceed the maximum sentence. So this provides you as legal practitioners and judges with the discretion to lessen the sentence. So if it's somebody who committed a burglary and they get 20 years, but really that doesn't, is 20 years really going to help this person being under the Psrb? Or perhaps 5 years would be more appropriate, or maybe 10, or maybe 2. What I'll say about that is that discretion, it cuts 2 different ways. So on the one hand, we want there to be fairness for people with mental health issues, and we don't think that people experiencing mental health issues should be punished. On the other hand, me personally, I don't view Psrb as a punishment. My philosophy around it is that people are getting the supervision, the monitoring, the resources, the treatment, all the things that they need to really become the person that they're capable of being. So when you do max sentencing, it can be a real deterrent for people who could otherwise really benefit from what we have available. And at the same time, if you take away the sentence too much, it might not be enough time for us to be working with a client in a meaningful way and get them conditionally released and integrated back out into the community. So those are just some things to be thinking about. I will say that there is case law. Psrb has no authority to change any sentences. The only way somebody can get an early release is if they no longer meet that jurisdictional criteria that I mentioned before. But otherwise, we can't say, oh, this seems like we could work it out in 5 years. Let's change it. We have no authority to do that. So it's really you as attorneys and judges who need to perhaps think about what type of time under the Psrb would be the most beneficial for the individual. The other thing I'll mention about it is that it seems to me that my observation has been, the overwhelming majority of these types of cases are stipulated. So it does seem that there might be some sort of plea deal that's happening between the DA and the public defender around, stipulate to the max sentence, and then we can stipulate all the other issues and not go to trial. And so I want to just let defense attorneys and DAs know that you can have some movement on that maximum sentence requirement. It just must not exceed it, but it could be under that. Take home message, sentence can be less than the max. So the last issue that I wanted to talk to you about regarding our GEI programs is that not all GEI adjudications need to result in a commitment to the Oregon State Hospital. This is a concept in our world known as a court conditional release, and I've seen them go super well and I've seen them fail miserably. And so I thought this would be a really helpful topic to kind of hit some key components, some key issues that we see, and provide some extra support. So since the dawn of the board, attorneys have always had the ability to have somebody be released straight into the community rather than going out to the being committed to the state hospital. I think it becomes really challenging, or historically it's been challenging, depending on what kind of resources the person or that community might have. There's also the perception of certain types of crimes, even if the person's pretty stable, that certain types of crimes, that it would not look very good for the person to be put on to conditional release, and issues of that nature. But it is important that everyone knows that no matter what type of crime somebody commits, they could potentially be eligible, and actually they're required to be conditionally released if the court finds that the person can be adequately controlled with supervision and treatment if conditionally released, and that the necessary supervision and treatment are available. So the second part to that came along in, I think this was also House Bill 3100, but don't quote me there. I think it was 2011. But that all defendants who have Class C felonies actually are required to have an evaluation to determine whether or not they can be conditionally released. So let me back up for a second and make sure I reiterate that the best practice for the Psrb is that a community evaluation is ordered in any case where conditional release is being considered. But in Class C felonies, it's actually required. So the take-home messages here are, if you are considering a court conditional release, the first thing you might want to do is pick up the phone and give our office a call and consult with us about the different options there might be. You might be out in a rural county that does not have residential treatment homes or the treatment kind of supports that are needed to have the person be safe in the community. But me as the Psrb knows, we are a statewide program. So that means we have people who might have committed a crime in one county, but we can place them in a whole different county. And we have resources across the state and vacancies happening all the time. So just because you as your local community may not have the resources, you can give us a call and we can kind of consult about what other options might be there, and also who should be doing that evaluation for you. So once you call and you figure out who the local Psrb community evaluator is, you would send that evaluator the signed court order for evaluation. That's a template that's available on our website. And you just kind of fill in the blank there. And along with that evaluation, to help that community evaluator really understand what's going on and whether or not they can manage the person safely on conditional release, you want to send them at a minimum that criminal responsibility evaluation and the police reports. There might be some other things that could be helpful for them as well, like mental health records, or if there's a competency evaluation that was completed, anything that's going to really help that evaluator make a really good informed decision about the conditional release plan is really helpful. The other thing to note about this is that evaluations can take a little bit of time. Statutorily, they have 30 days to complete them, and I know that our providers will work really hard to get them done way before those 30 days. But in any case, the recommendation to all of you is do not wait until the disposition hearing to bring up the topics. So you kind of want to get this evaluation ordered so that by the time the disposition hearing happens, the judge is able to look at the evaluation, look at the summary of conditional release plan, and determine whether or not there should be an order for conditional release versus a commitment to the state hospital. If that conditional release can be supported, in addition to the evaluation, the community provider will also develop a summary of conditional release plan. And that summary of conditional release plan will be incorporated into the final order. The other thing I like to caution people is that oftentimes people who are court conditionally released don't get the benefit of getting educated about what the Psrb really is when they don't go to the hospital. This could create a real fiasco because they don't understand they're under a board jurisdiction, they're under a conditional release plan, it is a court order, they haven't met the board, they don't have any kind of sense about who they are or what they're all about. And then they have this new person coming in and kind of telling them what to do. And, you know, Psrb is a no-nonsense program. There's treatment requirements, there's UA requirements, there's certain restrictions and things like that. So it's really important that you're talking, especially as a public defender, defense attorney, you're really talking to your clients about what it will mean to be under Psrb and then be conditionally released. We're going to talk a little bit about that in just a second. So these are all the templates. We have them everywhere on our website. So go check those out. And if you can't find one, give us a call. So what is it like for someone to be on conditional release? So this is not only important for people who are considering a court conditional release, but maybe some things you want to know about our program in general in terms of what we offer and what we're all about. So anyone under the Psrb could be on in any level of care. The question is, what is the least restrictive level of care they can live at where they could be safely managed in the community? So we aspire to be a part of the whole Olmstead Act and ensure that our clients' needs are being met with their level of services and they're not being warehoused in any way. But really, here's the percentages. I mean, you can see that only about 20% of our people on conditional release, and right now we have about 375, are in an SRTF. And we have, you know, about 40% living in more independent kind of placements with adult foster homes, supported housing, and independent living. So I think those are helpful numbers for people to understand. The residential treatment facility and homes, that is exactly the same level of care. Just to give you an overview, an SRTF is a 24-hour locked facility. People at the SRTF level of care can't go in and out without permission, but with time and participation in a level system, they do get passes and they go out into the community with staff and they connect and make connections with people and resources and things of that nature. As they're getting comfortable and making progress, they can be stepped down into any other level of care. People do not have to go in order, but often they do. Where a residential treatment facility or home is an unlocked facility where they have 24-hour staffing, but typically clients at that level of care are able to be on some kind of pass program where they can come and go as they please, as long as they're engaging in you know, meaningful activities and things of that nature and communicating with the staff. And we have adult foster homes that tend to be more like a 24-hour staff, but the staff don't stay awake at nighttime. We have supported housing. This is also the same level of care as our intensive case management programs, where staff are very part-time. So supported housing typically has a staff there 8 hours. Some programs do that in the morning when people wake up. Other programs might do it slightly toward the evening around curfew. It just depends on the program. And then our ICM programs are programs where people might be living independently in their homes and staff are going out to them on some kind of frequency, once, twice a week. Maybe for some people, it might be a couple times a day. It just depends on the person's risk factors and where they're at with their treatment. And then we have people totally independent living. That looks a lot like somebody who's outpatient. So they're coming to a clinic to do their therapy or group therapy. They might have their doctor appointments once every 3 months. They might have jobs. Let's get into some of the things that our people do. Here's what you get when you come under the Psrb. Like I said, I think it's the most comprehensive, robust system available out there to help our people who've really been in need and got themselves involved in the criminal justice system. People have the goal of achieving permanent housing. We have contracts throughout the state that we cannot have people who are homeless on conditional release. So housing is a big asset and a big benefit to those who are under the Psrb. They have access to their medical providers. We set them up with Social Security if they qualify for that, SNAP benefits, access to the VA if they're veterans, and making sure that we are getting them connected with culturally and spiritually appropriate services. What treatment typically looks like, the board mandates this 20 hours of structured activity when people per week when people are out on conditional release. Structured activity can leave a bad taste in some people's mouths because they see it as mandated, but really the goal and what we know from the research is that when people are engaged in their communities and they're out there socializing, volunteering, working, giving back, and doing other meaningful things in the community, that A, they have an opportunity to practice the skills that they've been doing, B, they are less vulnerable to things like isolation, they're less likely to have decompensation, they're more likely to be around others if they are experiencing problems, and then they could get the feedback from trusted individuals besides just their treatment providers. And so that is like the thought behind structured activity. We don't want people staying in their homes all day, every day. So part of those 20 hours a week, these are some of the things that might include going their medication appointments, doing individual therapy, engaging in substance use or self-help groups, substance use treatment, or not engaging in substance abuse, but in substance use disorder treatment or self-help groups. There's peer wellness specialists. They might be doing some skills training, group therapy, or they might be doing some kind of volunteering, employment or college experience. So when you're first in the community, you're more likely to be more treatment heavy with those 20 hours. As you're starting to do better and graduate from different treatment and develop your relapse prevention plans and things of that nature, you start to do more and more of those 20 hours in with your natural supports in the community setting. These are some of the restrictions that most clients on conditional release have. They're not allowed, in most cases, they're not allowed to have contact with their victims, but I will say we do have a bit of a pilot program in the works that enables some form of contact in a supervised setting that allows a conversation to have and to be had and for repair work to happen. That's one way that the contact can happen. The other way is that perhaps there is family therapy and other things being done while the person's at the hospital, or connections are made, or the victim is saying, you know, yes, I was the victim, but also I'm the mother and I want to have contact. And there's a mutual agreement that contact should be had. So no contact is typically the boilerplate, but there's definitely exceptions to all of that. Most of our clients are also participating in a level system. The idea is gradually getting things back together as they, some people have not been in the community for many years. Other people, the last time they were in the community, became too overwhelmed to deal with the daily demands of life. So we look at the level system as an opportunity for people to focus on yourself. Phase 1 is just getting yourself back out there, get your Social Security benefits in place, establish your connection with your treatment team. And then as people proceed through the level system, they get more and more privileges and less restriction. We do a lot of medication oversight. I'd say 90%, I don't have a stat for you, but I would estimate 90% of our population struggled with some kind of medication compliance or with the idea that they even needed medications. So we take medication oversight and changes in medications very seriously. We like to see significant changes be supervised, especially when people have been under a certain regimen that's worked for them for a really long time. There's driving and travel limitations. We typically have a payee assigned to help people with their finances early on. Random observed UAs are typically part of one's conditional release, although there could be exceptions for people who have zero history with substance use. We have to take that with a grain of salt because relapses have been on the rise in our population. I'm not blaming the legalization of marijuana on that, but the access of it and people offering it to clients has become kind of problematic for us and our clients. And then lastly, we do have a whole special conditions handbook that would be available for anybody who wanted to take a look at that. And these would be things like, you know, people who commit arson may have some restrictions around incendiary devices. People with sex offenses might have restrictions around internet and access to internet and phones or places where children congregate. So there are special conditions that can be added to anyone's CR plan. Some of the things that we have available to us as a Psrb, is we are the oversight, but we're not providing the direct oversight, in case that was an area of confusion. All of this work is being done by our fabulous community mental health providers. So almost every single county has some kind of CMHP. This would be the same group that would come in and do one of those community evaluations to see if someone's appropriate for conditional release. That is the same entity that's overseeing all the monitoring and supervision and treatment. And what they do is they consult with us on a regular basis, but more often if somebody might be experiencing crises, so that we can quickly respond to the crisis. We can see if there are things we can add to the plan, or a step up in level of care, or a local hospitalization. We have all different types of things that we might be able to use to help mitigate that crisis and avoid the person, we call it a revocation of the person's conditional release. That is an absolute last resort for us. We also have access to the law enforcement database system. So this way, anytime all of our clients are entered into that system, so anytime they have contact with law enforcement, we get a hit, and then we're able to kind of see what that was all about. Typically, we are also in that lead system. My phone number is in there, the case monitor's phone numbers are in there, and so if a law enforcement officer did have contact with one of our clients before they let that client go, we'd typically be getting a phone call to figure out what was happening with them. Another way we monitor and supervise is through monthly reports and incident reports. So we're reviewing those. And those are also used by the board to approve more privileges or step downs in level of care. So that communication helps us modify those conditional release plans, which is the next bullet point. And then lastly, like I said, we have this Revocation Authority, which we use very conservatively because we know that our population is likely to, most people will be likely to have some kind of increase in symptoms over the period of time they're on conditional release. And the idea is to teach them, this is the type of thing you need to do when you're in crisis. These are the resources that naturally exist. This is who you could talk to. And we're really trying to help people learn, maybe for the first time, how to identify those early warning signs and get help early on, so that they don't end up in an ultimate crisis. But if somebody is a danger to others, and we don't have those at our disposal, we are able to revoke them to the Oregon State Hospital. And I don't know if I want to say this because it might upset some people, but that Revocation Authority allows those patients to bypass any wait times to get admitted to the Oregon State Hospital. Okay, so the last thing I wanted to say, because this is fairly new, since 2016, ORS 137.223 permits those with GEIs to expunge them. Not all of them are expungible, but there is a lot of them that are. I am not sure, I don't have any data on how many people have been using this statute, but previous to the statute passing, even though some individuals who've committed different felonies were able to get those expunged, for whatever reason, the clients who pled GEI were not able to do that. So in 2016, we were lucky enough to have that pass so that there's some equity between, pleading GEI for a crime, you were mentally ill at the time of the crime, you shouldn't have less rights to have that expunged compared to somebody who had all the intent. So there's some pointers there that 3 years have had to pass since the most recent GEI. The person is no longer under our Psrb jurisdiction. There's been no other findings of GEI in the 10 years prior to filing the motion, and no convictions in the 10 years prior to the motion. There's a fact sheet, a fabulous fact sheet on our website with more information on that. Okay, so we're now going to move into our next program area known as the Psrb Civil Commitment. This is, the authority for this is ORS 426-701 and 702, and then I have the chapter of the OAR available for you there. If you think about our Psrb civil commitment, I'm going to show you the difference between a Psrb civil commitment and what you may know about traditional civil commitments in a minute. But the impetus for this statute came in 2013, and it was a DA response to what we would do for defendants who are alleged to have committed certain types of very dangerous acts, such as murder, sex offenses with minors, or rape and arson, when they are found not to be competent to aid and assist in their trial. And the specific language there is there's no substantial probability that in the foreseeable future, the defendant will gain or regain the capacity to stand trial. So when there's this never able determination, what is a DA to do? Well, the options would be, keep trying for 3 years or dismiss the case. And at 3 years, the case will be dismissed anyway, or the person could no longer be in the hospital, even if they were still dangerous. So this was a response to that. And essentially what it does is allows this civil commitment period where the Psrb accepts jurisdiction and oversees the person for a 24-month commitment period. Let me go into that next. For a 24-month period. And so here are the elements of what would need to be proved through one of those certified forensic evaluator evaluations. This is a civil commitment evaluation. And this is where the person, again, they have to be suffering from a qualifying mental disorder. That disorder has to be resistant to treatment. And what that means is, well, they were not even able to be, their competency wasn't even able to be restored. They were resistant to all of the skills training and the competency interventions, and nothing really made anything better. So that could be used as evidence for resistant to treatment. And because of that resistant disorder, again, here's that nexus comment, the connection between the disorder and the conduct. Because of the resistant disorder, the person committed one of several acts specified by the statute. Those acts are not called murder, rape, they're not called, they're described. So if you go to the statute, you can see what the description of the behavior was. So even though the person might have been charged for a lesser crime, it's the behavior that counts for this, not the name of the charge. The person is exhibiting symptoms of behaviors of a mental disorder that is substantially similar to those that preceded the act. So that one's a little challenging, but basically you need to have evidence of whatever that dangerous act was. There's some kind of similarity between the symptoms then and the symptoms now when you're trying to petition for this. That because of the mental disorder, the defendant presents a serious danger to the safety of others by reason of an extreme risk that the person will inflict grave or potentially lethal physical injury on other persons, and unless committed, will continue to represent an extreme risk to the safety of others in the foreseeable future. So that's another pretty high bar that needs to be evaluated. And then the last one is that the person cannot be controlled in the community with proper care, medication, supervision, and treatment on conditional release. So that's an interesting part of the statute, because actually people who are found, who are adjudicated under our Psrb civil commitment statute can be conditionally released as time goes on. So let's take a look at that. So you might be more familiar with that traditional civil commitment. There's a pretty high bar for that, but those are only 180 days. Those individuals can be placed in the community on what's called a trial visit. They can only be placed in the county of commitment. The standard there is imminent danger to self or others or gravely disabled, and that means like currently right now, there's a very fine time limit on that. And those can be initiated by a county health officer through or a judge or two people. That's different from the Psrb civil commitment. We already talked a little bit about the standard there, but these individuals, they can actually be conditionally released across the whole entire state, just like our GEI population. So again, we have some pretty rich resources out there and options for them if they were deemed to be able to be conditionally released. And these are initiated by statute. They can only be initiated by a DA or a court. So I'm going to talk to you about, I kind of explained a little bit that the reason this came up was a DA response to what to do with those people who are found never able to aid and assist. At that point, when the never able determination is there, that is when typically a DA might petition the court for this Psrb civil commitment. However, what I wanted to share with you today is a little bit of another possibility, another tool that might be able to be used. We've already had one case where, in anticipation of sentence completion from DOC, the person was placed under Psrb civil commitment. And we've had a few cases now that we've started to test but have failed for different reasons, and I'll share that with you, of PSRB civil commitment in anticipation of end of jurisdiction. So again, under PSRB, people are sentenced to a specific time frame. At the end of that jurisdiction, PSRB no longer has any authority, monitoring, supervision, or anything over them at all. And they have no authority to extend a PSRB jurisdiction at all. So this might be something we could use, and we'll take a look at that. Okay, so under the statute, I mentioned before that a certified forensic evaluator does this evaluation, but I misspoke. It's a little broader than that currently. What I will say is that the board would prefer that somebody like a forensic certified evaluator do these types of evaluations because of the complex issues around the diagnosis and nexus and the dangerousness. It's a pretty high standard to meet, and so the concern that we've had is that we have had some professionals who are mental health examiners do these, and they simply write a paragraph or maybe two saying, yep, they meet all the jurisdiction, let's do it. I don't think those really meet the threshold that the legislature intended. And that's something that we will be looking at. I'll be talking about this legislative work group that we have going on right now. And that is one thing we're looking at. But even worse than that, we have had a few people come under the statute and transfer to our jurisdiction without any type of evaluation at all. That should never happen. And if it does happen, my role would be to reach back out to the court to say, we really need to have a formal evaluation completed. So the best approach, forensic certified evaluator. Worst approach, nothing. Don't do the worst approach. Okay, so here are some requirements and safeguards. And I know this is a really busy slide, but it offers a lot of information for you in one place. So you kind of look at this in two ways. We have two statutes that govern this population. One is 426-701, and that kind of covers the initiation of the commitment. And then the second, which is 426-702, looks at after that 24-month period expires, where do we go from there? So upon commitment, the jurisdiction is transferred out of the criminal court system or whatever system the individual is in and over to the PSRB for a period of 24 months, not to exceed 24 months. The PSRB holds an initial hearing within 6 months, and at that time, they do have to make jurisdictional findings. So technically, it could be at that time that the board would be looking and seeing that there had been no evaluation completed at all, and they might order one, or they might be looking at other evidence that would substantiate the civil commitment. A safeguard and difference between this population and our GI population is that the individual really is committed for the 24 months. They don't have a right to request an early discharge from the board's jurisdiction. However, if the treatment team working with them, and that could be the hospital treatment team or the team working with them on conditional release, does not believe that the person meets the criteria, they are actually required to bring that before the board and have the board make a finding on that. A nice thing for the DAs is that even though the DA might initiate these, they can delegate the representation of the state to the AG's office, the AAG. And those are the same attorneys who represent the state during all of our GEI hearings. You could either delegate that, or you can participate in the hearings that we have and go the whole way through, or you can have the AAGs do it, and then you kind of do a consultation in the background. Like I mentioned, only the treatment team is able to request a conditional release during the commitment. So again, unlike a GEI client, the individual can't petition the PSRB to make a finding on conditional release on their own. And then our revocation statute still applies. So while somebody's under our commitment, we can, and they're on conditional release, we can always revoke them back to the state hospital if there's a dangerous situation happening that can't be managed. After that as that 24-month period is about to expire and is approaching, we have to start taking a look at whether or not a further period of commitment is necessary. And the spirit of this statute, if you think of it, of why it came about, is that an individual could really be committed in perpetuity. So as long as they don't even have the ability to aid and assist, which is it's a pretty low threshold. As long as they don't have the ability to do something like that, and as long as there's a finding that if they didn't have all of the monitoring and supervision and services in place, that they would become extremely dangerous again, they could be committed in perpetuity for every 24 months. That at the point of a recommitment and forward, that report evidence is established by the primary treatment prescriber. So that might be an OSH doctor, or it might be the doctor or nurse practitioner that's out in the community setting supervising them. And so they would be writing an affidavit saying that the person does continue to meet the criteria. We send those, the requests for that report 120 days prior to when the commitment is due to expire. What that does is it provides the DA or whoever's doing the representation plenty of notice about whether or not the board will be supporting what's called a certification, or supporting the client to lapse jurisdiction. When the DA finds that out, we have a full hearing, and we kind of have that conversation together, and the DA is able to request their own independent evaluation at their cost, to determine that no, this person really is still extremely dangerous and resistant to treatment. They need to continue with another period of commitment. If the recommitment is moving forward, it is certified. It's called certified by the Psrb, and the Psrb sends that paperwork over to the circuit court. And it's the circuit court where the client is residing. So even though their Psrb civil commitment could have started in Washington County, but then they were sent to the Oregon State Hospital. So at the end of the 24-month period, it is the Marion County Circuit Court who grants or denies the petition for the recommitment period. The other safeguard that the client has is that if they disagree, if the Psrb certifies and they get notice of all of this and their attorney is involved with that process, they do have the right to protest a further period of commitment. And what that does is there's a stay on the commitment that the board certified until the circuit court makes another finding. And that's how that works. Now, the safeguards for DAs who might be concerned if the Psrb is not supporting another period of recommitment. The DA, in that case, would have the opportunity to seek out a new competency evaluation. So we know that if we're looking at the traditional way these come about, the previous competency evaluation came up with a never able determination. And that's what got the person under this period of commitment in the first place. But now that they're no longer meeting jurisdiction, it might mean because they no longer have a qualifying mental disorder. It might mean that the symptoms don't make them dangerous anymore. And there could be a case to be made that, okay, well now with all this treatment, you would be able to aid and assist. So the DA is able to seek that competency evaluation out, and then and then move forward with the underlying charges. And typically there wouldn't be a statute of limitations, or the statute of limitations would be so lengthy that those charges could still be brought up. So just a few tips to think about on the front end with that. You do want to be thinking about preserving any evidence of those underlying charges. We did have a case, the person was, committed to the state hospital for, 20 years prior to this Psrb civil commitment statute even being a thing. So he had been there for a long time. His crime happened over 20 years ago, and it was a murder of his parents. What ended up happening is he did get better, and when he wasn't going to be certified for another period of commitment, it turned out that there was not a preservation of that evidence. So the DAs in that case could not come back and charge him with the murder or murders. So preserve your evidence. When you do petition for the civil commitment, if there are underlying charges, you want to make sure it's clear that you're getting them dismissed without prejudice, so that if the person no longer is under the civil commitment statute, again, you would be able to adjudicate those charges if that was necessary and a priority. And then I started saying the statute of limitation in these cases it's really pretty long. These are murder cases, rape cases, child molest cases, and major arsons. And so the statute of limitation tends to be pretty long. Another safeguard is that just because somebody doesn't meet the jurisdictional criteria for a Psrb civil commitment, they still may meet the traditional civil commitment criteria, and then they would just go into the regular civil system. We would be assisting them with discharging from any kind of Psrb related home to a choice model program. So there would not be any kind of drop in, okay, you're done with us, now go off, and no support. So we would keep the supports in place to help with that transition. And then guardianship appointments would be available as well. So now I just want to kind of slightly tweak it to say, usually these are initiated following a never able competency determination. But we've had a couple of cases come before us where we're looking at using the statute a little bit differently. So the first thing to note is that there's nothing in the statute that limits it to the competency stages of trial. There's nothing that says, resistant to treatment equals not able to aid and assist. That's an interpretation of the facts to meet that criteria. And so what we've been looking at is applying this Psrb civil commitment statute in cases where we're anticipating the end of someone's sentence under DOC or a jurisdictional lapse of their sentence under the Psrb. And here we would be looking at that extremely dangerous criteria. We'd be looking at the instant offense or any past conviction. And then also we would be looking at the symptoms the person is currently experiencing. So this is super important because you'd want to have really, and this has been kind of the fail of why we haven't been able to do this up to this point, is that there has to be really clear documentation that there is mental health symptoms being experienced in connection with that extremely dangerous act. For example, if somebody came under the Psrb for a burglary, and that burglary is nothing extremely dangerous, it does not meet the criteria at all, but at the end of that 20-year period, they were experiencing, they remained in the hospital and they were experiencing severe mental health symptoms, and everybody was concerned. We might be looking at something else. We might be able to use, if there was a rape or some kind of sex offense that preceded that burglary or was otherwise charged in the past, or some kind of perhaps institutional behavior that never got charged but is very well documented. Those things could be used as the basis for the instant, extremely dangerous event. So we could look at that. And then the resistant to treatment, and the other ways we've been using it, it's that never able determination. But in this case, it could be looking at institutional behaviors, the inability for someone to ever make it out on probation or make it out on conditional release, other evidence that medical and behavioral treatments just have not effectively managed. The person's been on a high security unit for, you know, the entirety of their jurisdiction, things of that nature. So the challenge with applying the statute currently is that the confidentiality and privacy limitations around record sharing with the original DA. So if we are a Psrb GEI case, we cannot go and hand over the DA a bunch of hospital records. There's an exception to that I'll get to in a second. Another challenge is, it's this one. So if the DOJ is formally representing the client rather than the county where the instant offense occurred, the AAG is not able to freely share those records with the DA. So if the DA is not the one representing the state in the case, they really don't have access to those records. And the challenge with that is only a DA can petition the court for this type of civil commitment. And then the third challenge has been this chicken and egg situation where everybody at the hospital believes, oh my gosh, this person needs to be civilly committed, but the DA cannot initiate it without having enough evidence, and then the hospital can't engage in in the evaluation until they get the order to do so. So it gets a little tricky. These are all things we're working on in the background to try to help, but here's some tips and other solutions to be thinking about. If it is a client who's committed a sex offense, either because that's their instant offense for the Psrb or they did it previous to coming under the Psrb, there is a statute, ORS 163A215, that really loosens the requirements around privacy in cases where there are sex offenders. And I won't get into the full details of that statute, but you can check that out. Some of the information sharing depends on their classification, and part of the statute allows us to freely share that information with law enforcement, and another part of it allows us to share information, but somebody has to request it from us. So check that out. Check out that statute. We are looking at a legislative concept that would authorize the AAG's office to initiate that 701 petition. So somebody's end of jurisdiction was approaching and the AAG would have knowledge that the person's not doing so well, and then they would be able to initiate that in a court. Another thing is just to encourage anybody who has, I don't know how much DAs look at the GEI cases once they transfer to the Psrb, especially if they're 20 years or life or something like that. But you might want to just take a look at how many cases your county has that has Psrb clients, and then look at the some kind of end of jurisdiction report, and see who's going to expire, and get in touch, reach out to the AAG to kind of discuss, you know, what's happening with the case. And then the last thing I wanted to talk about, we do have one case where the individual's DOC sentence was expiring. And this is how the courts got creative with petitioning for a Psrb civil commitment. The staff that were at the DOC were in really good communication with the DA's office. And so this person had tons of dangerous institutional behaviors. They knew that he, once they released him, he was going to wreak havoc in the community. They were very concerned about it. So what they did was they initiated traditional civil commitment, which actually under ORS 426074 enabled them to do what's called a pre-commitment investigation. That opened the doors to getting a ton of records. And while they reviewed that, they were able to say, hey, this is really way worse than just a traditional civil commitment. And they looked at the criteria for the Psrb civil commitment, and they were able to use the records they got through the pre-commitment investigation to petition for that Psrb civil commitment. So that was just, you know, an out of the box thinking that that somebody did, and yeah, something to be considering down the line. Okay, and so now I'm going to move into our second to last program that I'm going to talk about today, and that's our Psrb gun relief program. The big picture is that back in 1993, when the Brady bill passed, it required that, well, first it required that anyone with any kind of mental health determination would have some restrictions around being able to have guns, firearms, ammunition, things of that nature. It also prohibited people from selling or giving those firearms. And so a part of that whole system, or a part of that whole legislation, was that states were then required to report names of those people with mental health adjudications to what's known as NICS, the National Instant Criminal Background Check System, NICS. And what would happen is that anybody who was a firearm seller was required to go and check NICS to see whether or not the buyer had eligibility or this kind of restriction from the mental health determination, and then deny selling the firearm. Well, unfortunately, after the Virginia Tech tragedy, there was a huge investigation that occurred. And what they realized is that many states, and Oregon was included, were not actually reporting those mental health adjudications and getting them entered into NICS. And so, as you may or may not know, the gunman in that shootout, he did have a mental health determination, and had that been entered into NICS, the firearms that were sold to him would have been denied. And so Congress passed massive legislation, and it essentially said, states, if you're not going to report these names, you're going to have certain types of funding taken away from you. And also, we are making you establish some kind of gun relief program. So that way, there are concerns if people are getting put into the system, how do they ever get out of it? And so the gun relief program was established to help with that. And so in 2009, the Oregon legislature passed ORS 166273. This basically required the Oregon State Police to submit all the names. So we have a big meeting quarterly, and we all get together, myself and other people who oversee mental health adjudications, and see where we're at with all of that. And then the Oregon State Police submits all those names as those names are coming in. And then Psrb was delegated by the legislature to establish the program to restore firearm rights and let me be very clear here, this is not for everybody, this is only for people who have a mental health adjudication in the state of Oregon. I thought it was important to bring this up because I don't think many people realize that this program exists. And I'm not advocating for people to have their gun rights restored or anything like that. But curiously, we've only had about 10 completed petitions since the program launched in 2009. And you can imagine we've had, I don't know what the numbers could be, but thousands, tens of thousands of mental health adjudications have occurred, certainly over the years, even prior to 2009. And so we want to make sure that people realize that this is a program that is in existence. So if a mental health determination is a civil commitment, a GEI conviction, which could include a misdemeanor GEI conviction, or some kind of inability to aid and assist determination that's found during a criminal proceeding. The issue before the Psrb is whether the petitioner has demonstrated that he or she will not be likely to act in a manner that is dangerous to the public safety, and that granting the relief would not be contrary to the public interest. So it's really clear. It's not, it's not a standard we're applying regularly, and so it really is individually tailored, and we're taking a look at a pretty comprehensive application packet that the petitioner has to put together. That packet has a lot of instructions. We have tons of support materials on the website, but please feel free to call our office at any time if you have more questions about that. Okay, so the last program I'm going to be talking to all of you about today is the Psrb Sex Offender Classification, Reclassification, and Relief Program. As you may or may not know, the state of Oregon made the decision that to classify all people with a sex offender, all people who had a sex offense and needed to register. And the Board of Parole and Probation, Post-Prison Supervision, they took the majority of those cases and they have to handle those. The Psrb took classified cases for those individuals who had a sex offense and had ever been under the jurisdiction of the Psrb. So that may have been an individual who's under us for an arson, but had a previous sex offense. That was not a GEI. So that was just to get everybody up to date. And the classification system used the legislature approved the instrument of the Static 99R and what's called the LSCMI to engage in those assessments. And once those assessments were completed, each registrant was given a classification score of a 1, 2, or a 3, with 3 being the highest. These classifications were, well, at least with the Static 99R, could be done all through paper and record review. Registrants were provided an opportunity to put forth mitigating evidence through a survey that was administered to them. And they were also provided the outcome of the score and the opportunity to object to the score before it was finalized. We are thankful we're done with the classification part of that. I think I don't remember the number, but our agency classified, I think, over 200 registrants, and over a period of 3 years. And that was in addition to all the regular work we had. We had no additional staff support to do those. From here on out, we only register people who come under our jurisdiction with a sex offense. So that's our responsibility at this point. So the other part of the responsibility is the reclassification and relief part of it. So this program actually didn't launch until January of 2019. We do have one petition so far, and it's in process right now. But the rules around this allow for people, the whole idea behind this, it's not that you get to have the sex offender taken away or that it comes off your background check. It's still going to show up on a criminal background check. It still needs to be reported, and there's still other things that are in place for public safety. But what this program allows for is for somebody who has to register to no longer have to register. So that's paying the fees, and that is going to the Oregon State Police once a year on their birthday and filing and registering. So as I mentioned, level 1, those are people with the least risky or the lowest risk of recidivism in the future. And those people can apply for relief after ending their supervision. It doesn't matter where the supervision was, but for their sex offense. And I'm going to back up for a second. For Psrb to grant the relief, the sex offense had to have been their instant offense. So even if the Psrb classified that person, if their sex offense was something they were found guilty for, rather than guilty except for insanity, it's actually BOPS or the courts who would be looking to grant the relief. So for the Psrb, any level 1 sex offender registrant would come to us if they were adjudicated GEI because of that sex offense. And after they're done with their supervision for that, they come to us for relief. For a level 2, they are able to, they are also able to be reclassified to a 1, and then they're able to get relief from sex offender registration altogether. So for a level 1, it takes 5 years. That it's a 5-year period between their end of supervision to the time they can apply. For a level 2, it would be 5 years to go from a level 2 to a level 1, and then another 5 years to go from a level 1 to relief from having to register at all. Is everyone with me here? I don't have I don't have the benefit of feedback from all of you right now. It's a little confusing. So here's what's really important. A level 3 classification has meaning. A level 3 classification, anybody who's classified a level 3 ends up on the state's sex offender website. So people can search the name, and any level 3 sex offender would be up on that website, and you'd know where they lived. So these are people who have the highest risk for reoffending at some point in the future. And so the thing about a level 3 classification is that they are actually able to apply to the reclassification to a 2. All that will do is allow them to no longer have to allow their information not to be posted on the internet. However, that's it. They will always be a level 2. They will always need to register. They can never be relieved of that requirement. So those are how the 3 levels work. And if any petition is denied, a person could reapply every 24 months. So here's some key requirements. Again, these hearings are being run more frequently with BOPS. Again, we've only had 1 petition. We had 1 hearing on that so far, but the standard is whether the person has demonstrated by clear and convincing evidence that the petitioner is statistically unlikely to reoffend and does not pose a threat to safety of the public. So that statistical analysis is required to be conducted by independent evaluator. Again, we always recommend that it be a certified forensic evaluator who does that type of assessment. The burden of proof is going to be on the petitioner, and that petitioner will need to come in and have the hearing in person. There are a lot of other components to it. We have OARs talking about witnesses and evidence and things like that. We have our application and a lot of other helpful resources on our website for you. Some of you may have been thinking, I thought she said there were 5 programs, and I could have sworn she said something about responsible except for insanity. I decided not to include that program in this webinar, and that's because we only have about 4 or 5 people under our jurisdiction right now. There is a lot of similarities between that program and our adult program. Same rights around being able to be on conditional release and having frequent hearings and things of that nature. But I really wanted to focus, this has already been a pretty long webinar, I really wanted to focus on things that were distinct and could really help benefit all of you. If you did have more questions about our REI program for juveniles, please feel free to give me a call. We can set up a separate training for that. So now I'm just going to go through a few other things that you may want to know about the Psrb. We do have this fabulous website. Here's a little screenshot of the resources that are available for our attorneys and judges. One of those resources is our judge's guide. Just to note, it was published in 2017, so it is due for an update, but it's pretty up to date already. There haven't been too many statutory changes since 2017, but we do want to get that updated. The other thing I wanted to let you know about is for those of you who are doing this work often or run into issues where you're like, this makes no sense, or we need clarification, or you had an experience with Psrb that went wrong, please feel free to give me a call. We do have a pretty active legislative work group going on right now that started last August and will continue. And our plan is to develop some comprehensive legislative concepts for the next long session. And what I have here is a list of all those in the legal community who are participating on that panel already. If you know them and you want to offer your feedback to them, communicate through them to bring up certain issues, I would be fine with that. Just wanted to say a big shout out to all of them too, because it does take a lot of time and energy away from their regular work to participate. Please get to know us better. Maybe you know something about the Psrb from 10 years ago, or the last time you might have had a case like this, or maybe when you went to law school, you heard about this thing called the Psrb. We have published our first strategic plan for last year, from 2019 to 2024. We have some pretty big aspirations, and our vision statement is in that report as well. Feel free to get to know us a little better, and as always, feel free to give us a call if you want to know more. And lastly, I'll leave you with, it's been a while since I've done any survey with the legal community to see what kind of topics people are struggling with the most. This presentation was based on things that I've noticed in my position over the last couple of years, but I really want to hear from you all if there are things that you want to know more about, or sticky or challenging or complex, that would be useful for a presentation like this in the future. Please feel free to email me. And here's my contact information, the contact information for our great staff, and our website. And with that, that concludes today's webinar. Thank you.